Hello everybody. Okay, so this is the Friday class. It's a little late, sorry. See my glasses, suffering from a little bit of eye strain, so it's been really difficult for me to look at the computer screen and do my work and such. So let's look at the judiciary branch. This is the first lecture. Friday's lecture when we didn't have school. Monday, we'll be getting into a little more like discussion on the judiciary branch, role of the judiciary branch specifically, things like that. I want to, in this lecture, try and get through some of the stuff that perhaps doesn't warrant as much discussion in terms of it eliciting a lot of different opinions and stuff, because I like the opinions part of the class, when everybody tells me what they think. So, okay, let's get going. So I put the PowerPoint online. If you haven't gotten it, you can go on Moodle and grab the week 6, I think is what we're at right now, PowerPoint on the judicial branch. We'll be going through slides 1 through 13. And so yeah, so the judicial branch is the third branch of our government. The other two being the executive and the legislative. Executive members where the president is, executes the laws, does some interpretation of the laws through administrative discretion, which we'll talk about briefly when we look at the bureaucracy. There's the legislative branch, which passes the laws. The legislative branch has the power of the purse, funds the laws, funds the government. And now we're at the judicial branch, which interprets the laws. At least part of what they do. So, slide 2. What is the judicial branch? It's the state and federal court system. To put it briefly, the ladies and gentlemen in the long black robes sitting on a chair, banging a gavel, saying, "You're out of order." That's what we're talking about, to some extent, the judicial branch. So yeah, enjoy that. Okay, so slide 3. First, what are courts? What do they do? Courts, in a generic sense, they resolve disputes between parties. So we live in a civilized society. We have rule of law, people interacting with each other. We're going to expect at some point that there's conflict, and we need somebody to mediate that conflict. We've set up our judicial branch so that they can mediate the conflict. So like I said, the judicial branch, the courts, resolve disputes between, most of the time it's two parties, though lots of people can join a case so that it'd be multiple parties, but usually there's just one side and then the other side. Now a party in this case is not a woohoo yeah kind of party. It's a term used to designate a person in a case. So a party can be a person, it can be a state like Florida, North Carolina, Georgia, it can all be parties in a court case. It can be the U.S. government. It can be any sort of federal agency or state agency. It can be a business, corporation, nonprofit, ad agency, book publisher. You can also have parties being foreign governments, ambassadors, things like that. But a party basically in this case just means one side of the case versus the other party, which is the other side of the case. And sometimes the term party is used because of the fact that you can have multiple people or multiple organizations on one side of a case versus another. So yeah, courts handle the civil and criminal law. Civil law being lawsuits usually involving monetary damage or seeking to redress some wrong that doesn't necessarily involve, think of it not involving jail, basically. Civil law often said has to do with some sort of monetary claim or some sort of grievance against an employer or against the government, for violating rights or not applying the law properly, things like that. Criminal cases are things such as if you stole money or beat up a car, things like that. Necessarily want to go into horrendous crimes, but yeah. So courts do multiple things. Courts will find the facts in cases. Usually in most courts, there's a jury, at least in criminal cases, there's a jury that finds the facts of a case, and then a judge interprets the facts and doles out punishments and such. But courts, we can say courts find facts in cases, so they'll determine what has happened, who it's happened to, when it happened, why it happened, who, what, when, why, and then the where it happened. That becomes facts. The court then uses those facts to apply laws, interpret laws, protects, denies, or extends rights to various people, groups of people. The court can also declare laws unconstitutional in the sort of cases we're more looking at when it comes to the functioning of American government. Certainly there, a large body of the court deals with that criminal law side. But for the functioning American government, we're more concerned with that sort of what the court does in relation to the laws that Congress passes and how the court creates and mediates interaction between the citizens and their government, or different businesses and the government, or governments between each other, things like that. Thing to keep in mind is courts, if we traditionally think of courts sometimes like what's on the Law and Order or whatever. I don't really know that show that much. I assume the courts in there are jury courts with a judge, where the jury finds somebody guilty or not guilty of a crime. That's one type of court, but there are other courts in the courts we're looking at that don't have juries. Lots of courts don't have juries, as a matter of fact. They just have a judge, or sometimes 3 judges or more, or the Supreme Court, for example, has 9 judges, and the cases are decided by that judge. So yeah, that's what we're looking at. Slide number 4. Okay, so if you can believe this, state courts mostly handle state law, and federal courts mostly handle federal law. It's kind of amazing, right? One thing, though, to keep in mind is that both state courts and federal courts will sort of look at each other and look at the laws. State courts will look at federal law. Federal courts will look at state law in determining, the outcome of a case. If a state court, if you're suing the state for something, and the state court determines that there's a U.S. constitutional violation, they can certainly do that. The federal court, will sometimes look at relevant state law when it applies. So, something to keep in mind. Yeah. So, slide 5, more information on state and federal courts. The court system in the United States works on a hierarchy. So one thing to keep in mind, the Constitution only talks about the United States Supreme Court. The Constitution doesn't say that any of the courts exist. Doesn't establish any of the courts. U.S. Supreme Court is the court in the land. That's it. It says Congress can, as it deems necessary, establish other courts. And certainly in a country with 315-ish, maybe, give or take 5 million people, you would not believe that 9 justices on the Supreme Court could hear every single case. So the courts, the Congress has established a lot of other courts in the country. The state constitutions also established state courts, and there's similarities between the two. So what happens is the cases move into one level court. There's a decision reached. Usually, one party doesn't like the decision because they lose. That party may then decide to appeal the decision. The appeal goes up to the next level of courts. If they lose the appeal, if the other side then loses that appeal, they can then just send it up to another level, and then you eventually get to the state Supreme Court on the state side. And then if you appeal it beyond the state Supreme Court, you get to the U.S. Supreme Court, or on the federal side, you go U.S. District Court, Court of Appeals, and then United States Supreme Court. So the hierarchy, usually there's state level, you start at a state trial court. Lowest court just sort of finds facts and then makes some sort of ruling based on law. Then there's the state Court of Appeals, sort of a middle court, just handles those appeal cases when people feel like the trial courts have made the wrong decision. And then if the party that's defeated in the state Court of Appeals still thinks that they're right and the other side is wrong, they can appeal it up to the Supreme Court. Now, the Supreme Court, this is the state Supreme Court when we're talking about it. The state Supreme Court doesn't have to take any case it doesn't want to, just like the U.S. Supreme Court. I should say in most cases there are some cases where the state Supreme Court has original jurisdiction, which I'll talk about in a second. But the state Supreme Court in the states is usually the highest court in the state, and appeals in there. People do have the option to appeal to the U.S. Supreme Court, but the U.S. Supreme Court doesn't take that many cases every year. Usually less than 100 maybe. Sometimes maybe a little more than 100. But that's about the number of cases they hear every year. Federal courts, we have district courts. There are a lot of those. Then we have the U.S. Court of Appeals, sometimes called appellate courts, or the circuit courts. They're an in-between to the Supreme Court. So the Court of Appeals are often the last word on federal cases because the Supreme Court, like I said, doesn't hear that many cases. So if you lose at the Court of Appeals, you better hope that you have a really interesting case for the Supreme Court to take. Slide 6. Federal courts and American government. Like I said, we're not looking necessarily at criminal law. We're more looking at the interaction between courts and American government and legislation and executive action and things like that is what we're going to be concerned about. So, with that in mind, things that courts consider: are laws constitutional? How should laws be interpreted? How does the government properly function, in lines with the relevant legislation and in lines with the U.S. Constitution? Is the government doing what it should be doing? And the courts also look at what freedoms people have, what rights do they have, and how do courts and legislatures sort of navigate those rights and making sure rights are protected and making sure laws are enforced and things like that. You can think of the right to privacy, for example. So for a while there, so the right to privacy is not explicit in the Constitution. Nowhere does it say individuals have a right to privacy. the Constitution does say that we have the right to not have the government come in and search our persons, take our property, things like that without a warrant. This is in a criminal investigation. Within that, and within a couple other places in the Constitution, the Supreme Court interpreted a right to privacy. So in the modern era, since like 1960s, we've had this right to privacy that the courts have sort of granted the citizens, and it's affected the way the U.S. government, police offices, etc., how they can interact with the American citizenry. So, a couple landmark cases. Okay, so one of the big ones that talked about this right to privacy was it was a wire fraud case that the FBI was investigating. This guy, was inappropriately sending money from one place to another to either steal it or to avoid taxes or something like that. I'm not entirely sure. The important part is this. What the this is back in the late 60s, I believe, and there were telephone booths, if y'all know what those were. Hopefully some of y'all do. It's what Superman would go into to change. So this guy went into a telephone booth, shut the door behind him, made a phone call to do his illegal wire fraud stuff. The FBI had placed a listening device on the outside of that telephone booth. They recorded his conversation and arrested him and got a conviction based upon that recorded conversation. The guy sued, though, and said that the FBI needed a search warrant to record his phone call. The FBI said, listen, he was in a phone booth, public phone booth. We don't need a search warrant. And take this a little bit further too. Even when you're in your own home, the way technology works today is you don't necessarily need to have somebody or some device inside of your house for people to be able to track who you're calling and stuff. They could intercept it somewhere along the telephone lines or get in contact with the telephone company, things like that. So to get into your personal bubble, the government no longer needs to get to actually physically invade your personal bubble in order to get information about you, if you think about your personal space and your privacy. So what the court did is they said, listen, technology is changing. People are using these telecommunications, phones and such, radios, etc. And that's changing the way searches and seizures can happen. And we don't necessarily want to live in a society where the government can tap our phones without getting a warrant, for example, because where they tap our phone is not in our physical house or in our physical location, where we have our property is. So to help extend this sort of the right to having unwarranted searches and seizures, they inferred a right to privacy in the Constitution. So in this case of the guy doing the stuff in the phone booth, what happened was, since he shut the door behind him, the court ruled that he had an expectation to privacy within the phone booth. He shut the door behind him. For all he knew, nobody could hear his conversation. He was talking into a phone that only he had access to. People were walking by, sure, but there was this enclosure around him. So the court said he had an expectation of privacy, a realistic and reasonable expectation of privacy. In order to get that record, to record that phone call, the FBI needed a search warrant in order to violate his privacy, to get the information. And so they threw out that piece of evidence that the FBI had collected because they had violated his right to privacy. So that's an example of how courts interpret the Constitution, look at the way the government interacts with its people, and how they extend rights and interpret legislation surrounding those rights. Okay. Slide number 7, if it goes down. Okay, so we're going to have 2 slides here of key terms. I've listed the terms there. I'll go through and explain them. That's why you'll probably want to have notes out, or most of the stuff is in the book also. You can look up there. I'll try and give a hopefully a simplistic answer that's understandable. You can also ask questions in class. So, key terms to know when you're studying courts. Defendant. What's a defendant? It's a party that an accusation is brought against. Okay, so in a court case, you generally have somebody that's being accused of something, and somebody's bringing a case against that person, and that would be the defendant. So if I'm a landlord and I am running an unreputable apartments or whatever, I'm not keeping up with repairs, and because I want to make a lot of money, and making repairs costs money. A tenant of mine who's living in substandard housing, that's not conforming to, certain rights that people have when they're paying rent to live in places that are suitable to live in, they could bring a suit against me for not keeping up with the place that they're paying rent on. In that case, I would be the defendant in that. The next term, plaintiff, they would be the plaintiff. They're the one initiating the court proceeding. They're the one bringing the accusation. They're bringing the claim that I'm not doing the right thing by them. I have violated their rights, violated the law in some way. In a criminal case, if you're dealing drugs and the cops catch you, the state would be the plaintiff. The state is the one bringing the charge against you, the individual. You're the defendant. You're the one being accused of dealing drugs. Okay? So Court of Appeals, also called appellate courts. Lots of times they're used interchangeably when you read newspapers or watch the news or blogs, whatever. Just Court of Appeals, they're cases that, or courts that deal with appeals. So they're not like the lowest level courts that start hearing things, that hear cases first. Cases start in what are often called trial courts, or at the federal level, federal district courts. After decision is reached in that first court, when the case is first heard, if the person who loses the case appeals the decision, what they're doing is they're asking another court, usually we refer to it as a higher court, to review the ruling that the lower court made, to see if they got it right. These courts where things are being reviewed by, the courts that do the reviewing, are called appeals courts or appellate courts. Jurisdiction and original jurisdiction. So jurisdiction is two things, kind of, actually, with courts. Courts have jurisdiction. They have geographic jurisdiction, and they have subject matter jurisdiction. So geographic jurisdiction is a court has the power to review cases, to hear cases within a certain geographic area. So if there is a case between two people in Guilford County, or if, like, the Sheriff's Department of Guilford County arrests somebody in Guilford County, the Guilford County Court would have jurisdiction over that because it's in the geographic area of Guilford County. Now, there's also subject matter jurisdiction. Different courts are set up to handle different types of cases. There are some courts that are criminal courts that deal with, theft, murder, other crimes that exist. And then there are like family courts, so divorce courts, child protective service courts, juvenile cases, things like that. There are bankruptcy courts. That would be a specific subject matter. So yeah, jurisdiction. You got the subject matter and you got the geographic area come together to create jurisdiction for a court. So you can be a bankruptcy court that has jurisdiction in the eastern part of North Carolina. So cases that originate in eastern North Carolina, whatever that would mean in this case, that are bankruptcy cases would be heard by that bankruptcy court. Okay, original jurisdiction simply means, or is defined as, a court having the first crack at a case. Think of it that way. Like, if a court has original jurisdiction in something, they are the first ones to hear the case. So generally, the lowest courts have original jurisdiction in all cases. The appeals courts are the ones that don't have original jurisdiction. So if I were to sue, say I were to sue Guilford Tech for some kind of employment discrimination or malpractice or something like that, and if it were to go to courts as opposed to some sort of different arbitration process, there would be a court that would have original jurisdiction that I would have to go to first before I could go to an appeals court and or to the state or U.S. Supreme Court. Okay, standing. So standing is a legal term meaning, does a plaintiff have a right to bring a case before that court? All people to bring a case have to have standing before court to bring a case. It simply means, do they have, is the subject matter that the plaintiff is bringing eligible for review for that court? Does the person that's bringing the court case have a specific grievance against the person they're bringing the case against? Are they being specifically harmed? And if the court rules in their favor, will the person who has the grievance have some expectation to find relief from that grievance? So, an example of standing that was kind of controversial, EPA versus Massachusetts was a court case where the EPA sued, or the state of Massachusetts sued the EPA for not enforcing clean air, for not applying clean air legislation to global warming pollution. There's a lot of background here, but basically Massachusetts, before they could even bring a case, had to prove that, one, they had the right to sue the EPA. So that was step number one. Step number two, they had to show that there was some specific harm being done to Massachusetts by the EPA not doing what they wanted the EPA to do. And step number three, they had to prove to the court that if they won the case, if Massachusetts got what they wanted from the EPA, then that would lead to some sort of relief from the grievance that they filed. So this case, it was global warming. EPA was not regulating carbon dioxide, which they were supposed to do under the Clean Air Act by the definitions of what's a pollutant and things like that. The court decided that yes, Massachusetts is able to sue the federal government agencies. Yes, Massachusetts is going to experience, if the EPA doesn't do anything, some specific harm, immeasurable harm. Global warming will harm the state of Massachusetts. And yes, if the EPA begins to regulate the greenhouse gases, then Massachusetts can find some relief or be prevented that harm from global warming. So the court first said, okay, you have standing, Massachusetts. Then the task had to be for Massachusetts to prove that the EPA was required to regulate greenhouse gases under the Clean Air Act, and they successfully did that. Now the EPA is required to regulate greenhouse gas emissions from mobile sources, cars, trucks, things like that. They haven't exactly fully, completely done that yet. Obama's been really dragging his feet on doing that. Hoping that if he delays the EPA enforcing that legislation or that court decision, he'll be able to get Congress to pass some sort of comprehensive climate change legislation instead of him just sort of doing it however he wants to. But Congress, this has been going back to since he was elected in 2009, has not consistently refused to do anything on climate change. So even just within the past 2 years or so, Obama administration started to put plans into motion to regulate greenhouse gases, even though that wasn't what their first solution that they wanted was. Anyway, so that's standing. A brief is simply a written argument that both parties in a case present to the court before a case is heard. So generally they are arguments about the case and why the court should rule in their favor. They cite case precedent as to why the court should rule in their favor and not rule for the other person. Define precedent in a minute. Amicus brief. I had the other Latin word up there. Amicus is also Latin, but amicus curiae something. Just call it an amicus brief. That's what you'll hear most of the time on the news and in life, but know that that other word also means that. An amicus brief is also called a friend of the court brief. It's similar to the brief that somebody who's a party in the case submits to the court, except an amicus brief is a brief that a party submits to the court that doesn't have any interest in the or that doesn't have a stake in the specific case. So, in the Massachusetts versus EPA example, there were lots of amicus briefs given. So Massachusetts presented their brief because they were a part of the case. EPA presented their brief since they were part of the case. However, places like the Sierra Club, the Chamber of Commerce, the state of California, the Department of Justice probably submitted a brief also. These are friends of the court briefs. These are briefs written by people who have some expertise in the area, have some relevant interest in the case, even though they're not directly a part of the case. And they can help the court make a decision, is essentially what they're trying to do. They're giving the court different legal opinions. They're giving the court a wider range to look at with regards to how, if the court rules one way, how that might affect the broader society. More things for the court to consider, essentially. So Massachusetts may file their brief, but California can file a brief also, or Michigan, where a lot of cars are made, or used to be made, can file a amicus brief saying, listen, if you rule this way, it's going to help out this law, it's going to hurt this company, it's going to do this or that. That way the court has a wider view of what the case encompasses. That makes sense? Oral arguments. If you can believe this, they are arguments that are spoken out loud in court. So, there are briefs, which are the written arguments that are submitted before the actual court date. The judges review the briefs to get a sense of what each side is going to argue. The oral arguments are sort of statements on the day of the case that the different parties will make, and during oral arguments, the justices will question each party based upon their written briefs as to, why did you make this point? Why did you make this point? Don't you think this point was not very good in your written brief? What happens if we rule in your decision or in your favor? The oral arguments are a way for the judge or justices to have direct communication with the parties in the case. Okay. Slide 8, more key terms. Judicial review. Hopefully some of these will go a little quicker. Judicial review. This is basically just the term we use to define the power that the federal courts have to suggest that laws or actions taken by Congress or the president are unconstitutional. So laws passed by Congress are subject to judicial review. Important thing to keep in mind is one of the checks and balances on the courts is the courts just can't run in and review any law they want to that Congress passes or any action they want to that the president takes. They have to have a specific case to look at. So if I'm the president and I decide that I am going to, what would I do? I'm going to ban Walmart from operating anywhere. I'm going to instruct somebody in my administration. I don't think anybody is set up to do this, but I'm going to say Walmart cannot exist anymore in the country. It's an unconstitutional act, very clearly. But the courts can't come in and declare it unconstitutional until somebody sues me for my unconstitutional action. If nobody says, "Hey, Mr. President Roberts, we don't like this unilateral decision you're making, banning a country or a company from operating in our free enterprise economy." If nobody says that, nobody brings that to court, then tough. Sorry. See you later, Walmart. But obviously, the Chamber of Commerce, Walmart, somebody would bring a case. It would be reviewed by the court, and then the court could, in that case, if they found the case compelling, rule that my action was unconstitutional. It's the process of judicial review. Due process. Very long, complicated legal definition here with a lot of case precedent. It's one of the more important concepts in law. Essentially, though, we can reduce it to due process means not being treated arbitrarily by the government. The government has to treat you the same way as it does anybody else. It can't just make things up as it goes along as a way to prosecute you. People's due process rights are violated by governments. Lots of times this means that governments don't follow proper procedures when bringing a case before a person. That means they've treated that person differently. That person hasn't had the same right to an appeal or to have their case heard before, whatever they're supposed to be hearing it from. Maybe they didn't get a lawyer in the right amount of time. Maybe they were held too long. That would be a violation of their due process rights, and that's not allowed. Habeas corpus, very important legal concept, important right that we have as sometimes human people, other times just as American citizens. Habeas corpus basically means that if you are arrested or detained by the government within a reasonable period of time has to bring you into a court and say, hey, this is why we're holding you, and this is the evidence we have against you. It's basically you have the right to hear the charges that are being filed against you. And then you have the right to challenge those charges. In the olden days, before habeas corpus, lots of times people would be thrown in jail for no reason, or at least they would never know the reason they were in jail, and they would stay in jail, and they would never know why they were put in jail. So habeas corpus was meant to try and correct that. The Supremacy Clause of the Constitution basically just means it's Article like 4 or 6. It's either 1V or V1. I think it's Article 4. The Constitution is the supreme law of the land. Federal laws trump state laws. Basically, federal government is greater than the state government. If there's a conflict between the federal constitution and state constitution, federal constitution and state laws, or federal laws and state laws, the federal government and laws will win out every single time over the state laws and constitution. That's why, even though, for example, in North Carolina, our state constitution says that if you do not believe in God, you are not allowed to hold elected office. It says one of the requirements for holding elected office in the state of North Carolina is professing a belief in God. That is completely unconstitutional and completely unenforceable. It's still there on the books because whatever. Nobody's either had the courage to get rid of it so that our state constitution applies with the U.S. Constitution, or nobody's bothered to get around to it. But regardless, it's there, but it doesn't matter because the U.S. Constitution says that that is not okay. That's not the way we do things. So, if somebody were to make a case out of that, which actually happened in Nashville a couple years ago, or there was threats of that happening in Nashville a couple years ago, it's very obvious what would happen, that it would be struck from the Constitution, state Constitution. So we have the opinions. We have an opinion of a court, or a majority opinion, dissenting opinion, and concurring opinion. Opinions are written decisions by the judges. Okay, it's you have argued a case before a judge or multiple judges, and the judges or the judge writes their opinion, how they think the case should sort of come out and the reasons why it comes out that way. The majority opinion is also called the opinion of the court. It's the opinion that has the majority of justices on it. The dissenting opinions are the minority of justices, the justices that disagree with the ruling of the majority. They write dissenting opinions explaining why the court got it wrong, why the majority of justices got the case wrong. Then we have concurring opinions. Okay, concurring opinions, you can have concurring majority opinions or concurring dissenting opinions. Generally, just dissenting opinions are just called all dissenting opinions, but some people will occasionally refer to concurring dissenting opinions. But we definitely have, there's a majority opinion, a single majority opinion, and then you have concurring majority opinions with that. Basically, a concurring opinion is if you agree with the outcome of a case, but not necessarily for the same reasons, or you have additional reasons or reasons you want to take away as to why you think the case should come out that way. So, I am a justice, and I'm making, let's see, okay, so I'm ruling on a Jehovah's Witness case. Jehovah's Witnesses are, part of the religion is they are not allowed to pledge allegiance to the flag because of a passage in the Bible that says, thou shalt not worship false idols. Not quoting it, I don't know exactly what it says, but something about worshiping false idols. They view pledging allegiance to the flag as worshiping an idol, putting something pledging allegiance to something else that is not God. This became an issue in a lot of school districts when the school districts said that the Pledge of Allegiance was mandatory for all students. They would arrest the parents if the students did not pledge allegiance because of, the kids were disobeying rules. Basically what would happen is the kids would get suspended from school, and then because they were suspended from school, they weren't allowed to go to school. The parents would then get arrested because the kids were not in school like they were legally supposed to be, even though they were being suspended from school because of something they did in this particular case. The court ruled that ultimately in this case that free speech, the right to free speech does not compel students to pledge allegiance to the flag, and if anybody had ever made you pledge allegiance to the flag and you did not want to, what they did was unconstitutional. Keep that in mind, and you can keep that in mind in the future. But the court ruled it on a free speech grounds, actually. They said that students have the right to free speech. Pledging allegiance to a flag is part of free speech, and students don't have to engage in that speech if they don't want to. I, however, could offer a concurring opinion. I would agree with the court decision that the students were not compelled to worship or to pledge allegiance to the flag. But let's say I wanted to make that case on religious grounds, on religious liberty, that a school cannot, by pledging allegiance to the flag, you're enforcing a particular religious ideal on the citizens or preventing those students from practicing their religion freely. I could then say, listen, I agree with the majority's opinion or decision. I agree that the student should not be allowed to, or should not be forced to pledge allegiance to the flag. But I think the free speech issue was wrong. I think it's more about free religion, that the state should not compel people to violate their religious tenets by doing something that is against their religion. So I could do that. That would be a concurring opinion. So next, a precedent. That case I talked about, where the Pledge of Allegiance was ruled that it's not a mandatory thing that needs to happen in schools, that schools can't make it mandatory. That's a precedent. That means that in the future, when a school board says that no, all students must pledge allegiance to the flag and here's some punishments, when the case goes to court, the court will simply go, listen, we have a long established precedent about this case, so we're not going to hear it. A precedent is a previous legal opinion that has standing or has some sort of power in the present day. Courts will cite case precedent, previous cases, and how judges and justices have ruled on those cases as justifications or reasons why they need to rule the way they're ruling today. So the idea is that we have a sort of long-standing legal tradition. We have reasons why laws exist the way they do, the way things are organized, and the precedent is part of that history. It's part of our justification for why laws are and the way government is structured today. Now we do undo precedents, remove precedents, when culture, society, government, things like that change to require that. But to undo a precedent is kind of a big deal, and it's a little harder to do than just to follow precedent. So finally, stay. A stay of a ruling simply means that a court hears a case, makes a decision, says that because of this decision, this is what must happen. However, we know you're going to appeal the case, so we're going to stay the ruling. We're going to prevent. We're not going to say that the outcome of this case needs to happen until the appeals court hears the case. Probably doesn't make sense, so here's an example. A couple days ago, Thursday the 13th, one of the Virginia district courts ruled that Virginia's constitutional amendment against same-sex marriage was unconstitutional. Theoretically, this paves the way in Virginia to allow same-sex marriage in Virginia. All right. However, the judge that made that decision that same-sex marriage is legal in Virginia because it's protected by the United States Constitution stayed that ruling, meaning that that ruling does not go into effect. Because immediately after they made that decision, the people defending Virginia's ban on same-sex marriage said, we're going to appeal this case. We ask you to issue a stay of the ruling until the appeals court hears it. The judge that made the decision agreed that the ruling will be stayed, will not be enforced, will not be implemented until the next court hears the case. The reason why we do this is because there can be a lot of confusion and a lot of sort of irreversible consequences if we allow a ruling to go forward and then that ruling gets reversed later on. In Utah, they recently banned or got rid of the ban on same-sex marriage. A court in Utah ruled that the ban on same-sex marriage in Utah was unconstitutional, and that same-sex couples had the constitutional right to be married. For a day, maybe 2 days in Utah, same-sex couples got married because they were legally allowed to. The Court of Appeals heard the appeal, though, and issued a stay on that ruling. We have now about 1,000 couples in Utah that are married, but we don't know if their marriage is legal yet. We don't know where they stand because we don't know if the Court of Appeals will uphold that ruling from the lower court. And so that's the thing that staying of ruling is intended to prevent that sort of legal limbo that exists. Because what happens is that court then, the appeals court says that the lower court got it wrong. Those people are legally married. Are their marriages stripped, or do they get to keep their marriages? It's just that no future gay couples can get married in Utah. That's kind of the irreversible consequences that we're looking at and trying to avoid when we stay rulings. Okay. So, slide 9. What, 5 more to go? 4 more to go? Stick with me. So, district courts and appellate courts, looking at federal courts. There are, 49 district courts. There's 89 among the U.S. states, 1 for Puerto Rico, 1 for the District of Columbia, and then there are 3 for the various U.S. territories. Yes, the United States has territories. We're an empire. Yay, us. Within these 94 district courts, there are 679 current, at least, positions for federal district court judges. Sometimes not all these seats are filled because of the Senate confirmation process, but they're there. So a case originally goes to the district courts. If somebody appeals the decision from one of these district courts, it will then go to one of the 13 circuit courts. They're also called the Federal Court of Appeals, Federal Appeals Court. There's 11 of them for the states, 1 for D.C., and then 1 for a sort of special topics court. These courts handle specific geographic areas. There is a map in the book page. Did I write it up there? Yeah. Page 372. Let's see. There's a map of the U.S. Circuit Courts where the geographic jurisdictions of those courts. So, District Court number 1, Court of Appeals number 1 is up there. I think that's number 2, number 3, etc. Yep, got it right. So, District Court number 3, for example, is just Pennsylvania and New Jersey. District Court 9, Court of Appeals, Circuit Court 1, Court of Appeals 1, Court of Appeals 2, Court of Appeals 3. The 9th Circuit Court, or the 9th Court of Appeals. These are all things that they're called interchangeably. Sorry about that, but that's the way it works. Involves Arizona, Alaska, Hawaii, Nevada, Idaho, Oregon, Washington, Montana. It's often known as one of the more liberal court of appeals, which is fun to know. Oftentimes, the circuit courts are the final word on court cases because the Supreme Court handles so few cases every year. So if whatever the circuit court decides, that's usually the decision you get, unless the Supreme Court decides to hear your case if you appeal it. Okay, so slide 10, U.S. Supreme Court. It's the only court mentioned in the Constitution. So it's the only court that constitutionally exists. That means theoretically, though it would be a terrible idea, Congress could get rid of every other court in the land if they wanted to. They're not going to do that, though, because that would be a nightmare. So the Supreme Court has 9 justices. One thing to keep in mind is we generally hear about cases being decided by all 9 justices. However, and this is true of every court in the nation, a judge can recuse herself from a case. So in the Supreme Court, that may mean that only 8 people decide a case. Recusing yourself from a case means that you decide not to make a ruling on it. You sort of don't take a part in the case as a judge. You would do this if you had a conflict of interest in it that would perhaps render doubt upon your objectivity in the case. So Elena Kagan, for example, she was nominated by Obama and confirmed to the Supreme Court. She was originally the Solicitor General of the United States, which means she was the nation's highest attorney. Whenever the United States argued a case before the Supreme Court, she was the person that argued that case. There were a number of cases in the pipeline that she had prepared and was going to argue before the court, that in her first term on the court she recused herself from because she had what would at least appear to be an obvious conflict of interest in the cases because she was preparing arguments on behalf of the government. So she didn't take part in those, and it was just decided on by the other 8 justices. The other case is if a justice dies or resigns and the court hears cases before someone else can be appointed to fill that seat. That's why you wouldn't have the full 9 of the Supreme Court ruling on that case. The current members, they're listed there on the slide. You can read them. I listed them, and that's actually on page 373. It's in order of when they were nominated. And I put, by who they were nominated. And I also put on there the political ideology, or how we generally consider that person to vote. So right now, moving to slide 11, right now we currently have what are seen as 4 liberal members of the court, 4 conservative members of the court, and 1 swing voter. That one swing voter is Justice Kennedy. He is considered more of a conservative member of the court. He will occasionally vote with the liberal members, but he's a conservative-leaning swing voter. So in a lot of cases, you'll see the court decide an issue by a vote of 5-4. That person that switches back and forth to make one a majority of the other is generally Justice Kennedy. So when justices are appointed, they're appointed by the president, confirmed by the Senate. Once they're appointed for life. They can be impeached if they do something really extreme and terrible. That's not likely to happen. So generally, the only thing that removes them from office is they die. Because of that offers them supposedly at least some protection from political pressures. So once a justice gets appointed to the Supreme Court, there's a period where you don't know exactly how that justice is going to rule, because even though, for example, Obama may have appointed you to the court, that doesn't mean that you're going to be a liberal on the court. You could be a conservative. As a matter of fact, we have lots of cases. So, a funny story. My webcam software apparently only records to an hour and then it shuts off. So I was definitely lectured to basically the end of this before I realized that I had been cut off. So that's why the weird cut, and here I go again. Are we on slide 11? I was just saying, according to the video I watched, that Obama... Okay, yeah. So, the final point there was Earl Warren, for example, one of the most liberal justices that we've had, was actually appointed by Dwight Eisenhower, a Republican. We had a couple of justices that were appointed by Reagan and Bush and Nixon that are no longer there, that were more liberal than conservative. So even though you may be appointed by a liberal, doesn't mean you're going to be a liberal on the court. You may be appointed by a conservative, doesn't mean you're going to rule as a conservative on the court. Because once you get on the court, you're protected from those political pressures, so you can rule however you like to. So one thing to keep in mind, though, about the current state of the court and sort of the history of the Supreme Court is that the court has gotten decidedly more conservative since 1980. There are two reasons for this. One, Republicans have held the White House for longer than Democrats, 20 years to 13 years, which has given them more opportunity to appoint Supreme Court justices. The other reason is both the Democrats and conservatives are more conservative than they used to be. So, take a guy like Nixon. Nixon's pretty liberal, actually. He's known as being one of the fiercest anti-communists in American history. One of the, there was no doubt Nixon hated communism. He hated socialism. He was a real, took a very tough stand against those ideologies, was very fierce and vocal in his opposition against it. He was known as being an anti-communist crusader. In many ways, Nixon is, at least on economic policies, way more liberal than Obama is on economic policies. Nixon's healthcare law that he wanted to get passed is in many ways more liberal than Obamacare. Nixon created the EPA. Obama's been dragging his foot on enforcing some EPA legislation. Nixon presided over much higher taxes, supported higher taxes than Obama did. Nixon created he created the EPA. He presided over an expansion of the federal government, an expansion of the regulatory power of the federal government. Obama has presided over a reduction of the overall reduction in regulations and regulatory power of the government. He's expanded it in some areas, of course. So, since, Democrats, since starting with Carter, have gotten more conservative, and Republicans have gotten more conservative also, the entire country has shifted more conservative, and the court has reflected that leaning as conservatives on the court are replaced with more conservative members, and liberals on the court are replaced with liberals that are more conservative than the people they're replacing. So, something to keep in mind about how that court shifts. Ruth Bader Ginsburg considered the most liberal member on the Supreme Court right now. She very well may be the next Supreme Court justice to go. If she goes while Obama is in office, either resigns or if she unfortunately passes away, she has cancer. So, if Obama gets to replace her, Obama will replace her with what Republicans will shout as being a liberal. However, once she goes, the court will just automatically take the shift, more conservative shift, because undoubtedly Obama will appoint a liberal who is more conservative than Ruth Bader Ginsburg, because that's just the way politics have moved in this country. And the people that are in power represent that conservative swing that we've had since Jimmy Carter. So that's fun. Slide 12. And then slide 13. So Supreme Court decisions. Supreme Court decisions are the final law of the land. There's no appeal, no nothing. If the Supreme Court rules a law unconstitutional, this Congress or whoever made that law, can try and pass an amendment to the Constitution to make it then constitutional. But that's very hard to do, and essentially the law is then nixed. When the Supreme Court makes a decision, it affects future law, future decisions because of that precedent that is created. A couple of factors and decisions. So if you didn't know, sometimes justices are not thought of as making decisions based solely on the facts of a case. They may have other things in mind. As we've talked about, there's no such thing as being without bias, so everybody has a bias. Also, there's no such thing as being objective, because you're always sort of within some sort of bias when you make decisions. The idea, though, is that hopefully when you're making decisions, you're aware of your bias and you're not necessarily making decisions for like hyper partisan or egotistical or narcissistic reasons. Hopefully the reasons are not about yourself and your desire to impose everything on the world. It's about you saying, I just think this is the right thing to do, regardless of whether or not I agree with it. There's certainly some things that I wish were the case, but I also recognize are not constitutional, and therefore if I was on the Supreme Court, hopefully I would have the wisdom to say, I wish we had this thing, but there's nothing in the Constitution that allows us to have that thing yet, so I would have to rule against it or whatever. Sometimes, though, that's not always what happens. So one way that does not happen is justices care about their image, and justices also care about the credibility of the Supreme Court as an institution. So one thing, the Chief Justice is the leader of the court, and when whoever the Chief Justice is, that's often known as their court. So we have currently John Roberts as the Chief Justice, and it's known as the John Roberts Court, or the Roberts Court. We had Earl Warren was the Chief Justice. We had the Warren Court. People are going to remember the Roberts Court as a specific sort of court, like an era in the court. John Roberts wants the court to remember it as his era, the Roberts Court to be a good thing, not looked at as being a terrible court, for example. So when John Roberts makes decisions, he's going to think about that. He's also going to think about the credibility of the court. So one thing that the early Roberts Court got some criticism for, or people complained about, was as you would expect with 4 conservatives and 1 conservative-leaning swing voter, the court made some more conservative decisions in a sort of traditional conservative sense. They overturned some long-standing judicial precedent, which you could say, if you think of liberal as being open to change or wanting change, and conservatives as being sort of holding to precedent, holding to tradition. Roberts' court in some areas has been liberal as it's overturned a lot of precedent, but traditionally we think of it as conservative since he's applying conservative ideals of government right now. Anyway, a lot of people were getting kind of fed up with the court, especially after Citizens United. That court case was a very conservative decision. Said since corporations are people and money is speech, corporations have unlimited ability to spend as much money as they want to on political speech. There was a lot of talk that, this is just we know how decisions going to be made on every case because we know the ideological breakdown of the members. John Roberts, though, was the person that wrote the decision and came out and said Obamacare was constitutional, which surprised a lot of people. A lot of people were like, Kennedy's going to be the swing voter. We know the 4 conservative members will vote against it. 4 liberal members will vote for it. And looking at that split. John Roberts, though, said the Obamacare was constitutional. However, what's interesting is that in doing so, he actually made a very conservative argument for why it was constitutional. He said that it was constitutional, the mandate part of it was constitutional under the government's power to tax, not under the government's power to regulate interstate commerce. So he gave Obama a judicial victory while establishing a very conservative judicial precedent, which is very interesting and kind of brilliant by him. But there's some discussion that maybe he ruled in favor of the Affordable Care Act, in part because he was thinking about the credibility of the court, that if the court continued just to make conservative decision after conservative decision, that people would lose faith in the court as being an independent arbiter of national law, and that's something that all Chief Justices are concerned about. So we see a lot of pressure on Chief Justices to at some point sort of throw a bone to whatever side is getting hammered at the Supreme Court, to at the very least maintain that credibility among the populace, because in order for the Supreme Court to have power, they have to be viewed as an independent arbiter, somebody that can come in and make decisions fairly. So there are other things, personal ideology, personal upbringing, morals. You saw a lot of that. Sonia Sotomayor, in some of the recent racial discrimination cases and sex discrimination cases that have come before the court. In the oral arguments, you've seen Sonia Sotomayor make really, really amazing pointed comments at some of the, like Antonin Scalia, for example, old white guy in the court, for saying things that she felt are just, very out of touch. She's like, you're obviously didn't grow up where I did. You haven't had to face the same challenges I have. Come on, you don't think racism's real anymore? Make pointed comments like that. It's been kind of fun to see those two interact. Same thing with her and Roberts in that regard. Anyway, that's fun. But their, upbringing, political ideology, interpretation of the Constitution, how all that fits together affects their decision. There's also this general idea of a rational basis. We'll go into this some more on Monday about how the court applies different standards to different decisions. But there's this general idea that decisions by the court and what the federal government does has to be on this rational basis. The government has to have a compelling secular reason for doing something. It has to prove that there's a governmental interest there, and then that government interest has to be logical, has to be it can't be religious, is sort of the big thing there. And it has to be sort of in that tradition of the Enlightenment when our Constitution was founded and what our founding fathers were looking towards when they created the Constitution. Sort of like the founding philosophies of the country were those of the Enlightenment, the sort of getting away from God and religion as a justification for everything, and sort of looking towards people and trying to figure out a justification for why we do things that are more like what they would call rational, more people-centric, sort of don't have or don't need divine intervention for why we do things a certain way. And the court, applies. That's one thing that the court definitely looks to when it interprets the Constitution is, are these laws following that Enlightenment tradition of secularism, of applying the sort of quote-unquote objective reasoning. Obviously there is not objective reasoning in a strict sense, but is the justification good? So that's the part that generally people hope they apply, but of course, some of that other stuff comes into it. So final sort of wrap-up review. So all judges, federal judges, are appointed by the president, and they're all confirmed by the Senate. So all the district court judges, all the appeals court judges, and the 9 Supreme Court members are all appointed by the president, and they all need to be confirmed by the Senate. I don't know the last time we've had the Senate not confirm a presidential Supreme Court appointment. Generally, the Senate doesn't like to block the presidential nominations to the Supreme Court, even if the other party's in control of the Senate, because if one party, like say the Republicans, take control of the Senate in 2014, the election this upcoming year, and Obama makes a nomination to the Supreme Court, and Republicans then get rid of that person, or say, don't confirm his nomination, all of a sudden that opens up the door where Democrats can do that back to the Republicans. And so there's this sort of like, mutually assured destruction, kind of, with the relationship between the Americans and the Soviet Union with nuclear weapons. Neither side is willing to filibuster or prevent a halfway qualified presidential appointee to the Supreme Court, because once one side does it to the other side will do it to them. And so that's the way that goes. Harriet Miers was appointed by President Bush to the Supreme Court. She obviously is not on the Supreme Court. The reason she didn't make it was because actually conservatives raised a lot of concern about her, and actually most of the concern was that she was a woman. The pushback against her, and she withdrew her name from consideration, Bush pulled back her appointment. She was a woman, and so conservatives were very concerned that because she was a woman, she would rule favorably on reproductive choices for women. Not rule in their favor, rule favorably for women's reproductive rights, rule in a pro-choice fashion, rule for increased access to contraception, things like that. So that's why he had to pull back her nomination and then appointed a man, because men apparently can be trusted to rule against women's reproductive rights, and women can't be trusted to do that. That was in 2005 or 2006. But she was the most recent person to be sort of seriously floated that we knew was going to be up there, appointed, that then got pulled back. But she was pulled back from conservative pressure, not because Democrats weren't going to appoint her. There's no qualification. You need to be a judge to be appointed by the president to one of these judgeships. You just need to be appointed by the president, confirmed by the Senate, though generally there's some sort of law background. In the past, we've had like governors who've been appointed, or senators or House members that have been appointed who have no legal background at all, but they've been appointed by presidents and confirmed by the Senate to serve on the Supreme Court. There's a little bit of talk that Obama may have chosen to appoint like Bill Richardson, who is governor of Nevada for a little while, but he didn't. And I don't think Bill Richardson has a legal background. He's just governor. So, courts, as we're concerned about, rule on laws, the interpretation of laws, the legislative intent of laws, which is something we'll talk about a little bit more on Monday, and the constitutionality of laws. And the final thing is everybody gets their day in court, but they don't necessarily get a full access to the full appeals process. So everybody gets their day in court, and everybody can appeal their decision. Whether or not their appeal is heard depends on if the appeals court wants to hear it. They'll review the case, and they'll say, okay, yeah, we'll take a second look at this, or they'll say, nah, we'll just let the lower court ruling stand. There isn't a good reason to appeal here. So everybody has that kind of due process where they can appeal decisions, but appealing a decision doesn't mean that something that you'll have your second day in court, for example. So yeah, the Supreme Court, I guess one last word. As I said before, I hope, takes the cases it wants to take. Generally, they're either interesting to the court. There's a lot of contradictory lower court rulings. So, for example, on the Affordable Care Act, there were district courts and circuit courts all across the country that came to different decisions on if the Affordable Care Act was constitutional, not constitutional, if certain parts of the law were upheld or dismissed, things like that. Given all that confusion and the particular importance of the law, the third reason I put there, the Supreme Court took the case. The Supreme Court, though, finally, another reason, has original jurisdiction over some cases. We won't go into that. Just know that the Supreme Court has the first and final word on some specific court cases. They're not just an appeals court for everybody else. So, sorry that went a little long, but I guess even though I was only doing one day, I am cramming like 3 days, hopefully, into 2 days. So, have a good weekend, and I'll see everybody in 36 hours, thereabouts, maybe. Peace.